Welcome to this videotaped presentation of ethics training for California state officials. I'm Bill Lockyer, the Attorney General in California. With me is Karen Getman, Chair of the Fair Political Practices Commission. We want to take a moment to tell you about the presentation you're about to watch. This presentation is a collaborative effort between my office and Karen's. The purpose of the training is to provide you with an understanding of the ethics laws that govern your daily lives as state officials.
In 1998, the legislature passed and the governor signed AB 2179. This law, effective on January 1st of 1999, requires each state agency to provide an ethics orientation to certain of its officials. Prior to conducting these courses, agencies are required to consult with the Fair Political Practices Commission and the Attorney General's Office regarding course content. In an effort to ease the burden of conducting these orientations and to ensure the uniform flow of information, our offices have created this videotape presentation of ethics training that may be incorporated into an ethics orientation by any state agency. We also will be offering this core ethics orientation in an interactive internet format and perhaps a live lecture format.
Let me take a moment to tell you about the Internet course. As you know, web-based training is the wave of the future. We think this ethics course is the first time that a state has attempted this type of training in an Internet format. We're excited about the possibilities which this kind of training format offers. There are two primary factors that prompted an Internet format. First, this format allows state officials to take the course at a time most convenient to them. Second, this format provides the ability to interact directly with you as you take the orientation by providing you with fact-based questions that will allow you to apply the knowledge that you've just gained. This approach should make the orientation more engaging and simultaneously provide you with instant feedback on your understanding. We would appreciate your feedback on the Internet course.
Let me take a minute to tell you about the core course that our agencies have prepared for you. This course is not intended to make you into an expert. Rather, the goal is to expose you to ethics laws and their application in an effort to create an early warning system in your mind concerning potential conflict of interest situations. Once you can identify basic conflict situations, you should consult with your agency's legal counsel or other resources when conflict issues arise. We will identify a variety of resources for you at the conclusion of this videotape. Each of the laws that we will examine in this course must be considered independently. It is quite possible that any given transaction could involve more than one law. In that vein, it is important to realize that a term such as financial interests may have different meanings in the context of different laws. Similarly, conduct that is permissible under one law may violate another. Because these laws are complex, it is essential that you maintain close contact with your legal counsel when ethics questions arise. The Office of the Attorney General is available to assist your counsel in analyzing ethics questions. In addition, the Fair Political Practices Commission can advise either you or your counsel regarding the provisions of the Political Reform Act, either orally or in writing.
There are some requirements that must be satisfied if this videotape presentation is to count toward your ethics training requirement. The law requires all covered state officials to complete an ethics orientation conducted by their agency every 2 years. Under the law, your agency must provide a public record of who has attended its ethics orientation. If either this video or the Internet course is a part of your agency's ethics orientation as mandated by the law, you need to make sure that you're following your agency's procedures in completing this aspect of the orientation. 2 Deputy Attorneys General will be participating in this training program. Ted Prim is the editor of the Attorney General's pamphlet on conflict of interest. He has specialized in conflicts of interest for more than 20 years, first as a lawyer for the Fair Political Practices Commission and subsequently as its executive director. Since 1983, he's been a deputy in our office, where he's continued and expanded upon this specialty. In 1991, Ted was the first winner of the annual Public Lawyer of the Year Award, presented by the Public Law section of the State Bar. Kathy Van Aken is a distinguished deputy with our office. She's represented the state and its agencies in a number of complex court cases. She will be providing you with questions during the training to test your understanding of the material being presented.
Steve Churchwell from my office also will be participating in the training. Steve is our general counsel and has practiced law in the conflict of interest arena for more than 10 years, both in private practice and with our office. He has organized and taught countless seminars on this subject over the years. Now that we've dispensed with the essential preliminaries, let's get on with the show.
Hi, I'm Ted Prim from the Attorney General's office.
And I'm Steve Churchwell from the Fair Political Practices Commission.
We're going to be telling you about conflict of interest laws in California. During today's presentation, which will last 2 hours or so, we'll be covering about a dozen of these laws. And if you find yourself at some point thinking that these laws are complex and perhaps overlapping in some respects, that's because they are. It's difficult subject matter. We've tried to break it out for you and make it as understandable as possible in order to help you familiarize yourself with your obligations as state officials. Let me tell you for a few minutes about the format we'll be following. Steve and I will be making presentations on the various laws, and then intermittently throughout we'll go to questions that allow us to have a little fun with the material that we're discussing and be able to apply it in some real-life situations. And then we'll try to do some things to highlight the high points of these items as we go. And then finally we'll provide you with some resources that you can use in order to help you figure out how these laws may apply in particular situations that come up during the course of your service with the state of California. Steve, you want to start us off with a discussion of the Political Reform Act, and I should tell you in advance that this opening portion will be the most difficult and most complex portion of the course materials we're going to cover today. And once we finish that part, things will lighten up from that point on.
Thank you, Ted. During this course, the 5 laws that I will be describing are part of the Political Reform Act. These topics are financial conflicts of interest, the regulation of gifts, the ban on receiving honoraria, conflicts caused by campaign contributions, and finally, post-employment restrictions. The Political Reform Act also established the Fair Political Practices Commission. The FPPC provides written and telephone advice to people who have duties under the law. We also produce excellent brochures on each of the topics I will be presenting. You should also be aware that the Act provides for administrative and civil fines as well as misdemeanor penalties for violations of these laws. So let's turn to conflicts of interest under the Political Reform Act. There are 2 aspects to regulation of conflicts. The first is disclosure, and I think many of you file a statement of economic interest annually, what we call a Form 700. It has listings of your financial interests. You should get a copy of your agency's conflict of interest code. This is very important because your agency's code, which is adopted as a regulation, will tell you which economic interests you must disclose annually. If you are listed in the code, your position at your agency, you're known as a designated employee. Now, the second aspect of conflicts under the Political Reform Act is known as disqualification. This law prohibits you from being involved in certain agency decisions. Now, one thing I'd like to mention at this point is that we're going to be talking about quite a few dollar amounts, mentioning $250, $1,000 throughout this talk. And I'd like to let you know that these numbers are subject to change. There is a bill in the legislature that could increase some of these amounts by as much as 500%. If you look at our written materials and the internet course that goes along with this, those numbers will be updated as soon as possible. Now, the basic conflicts law is relatively straightforward. No public official shall make, participate in, or try to influence a governmental decision if the official knows that he or she has a financial interest. Now, the law gets complicated right away when it begins to define financial interest. A public official has a financial interest in a decision if it is reasonably foreseeable that the decision will have a material financial effect on the official's immediate family, or on one of 4 economic interests that I'll describe in a moment. Remember, the Act regulates only financial conflicts of interest. We believe that the key to avoiding violations of this law is to keep your economic interests in mind and to recognize when they may be impacted, even remotely, by a decision that you're making at your agency. The FEPC has developed an 8-step process for determining whether you must disqualify yourself under this law. It is not that complicated because normally the focus will be only on 1 or 2 of the steps. So let's run through those steps now. Step 1, is a public official involved in the decision? I assume that almost everyone viewing this videotape fits within this definition. It includes every member, officer, or employee of an agency. Also included within the definition are some outside contractors of agencies, including consultants and investment advisors. If you have questions concerning these people, please contact the FEPC or your attorney. Step 2, is there a governmental decision? The Act covers making a decision, participating in a decision, such as by making recommendations to the decision maker, and even considers attempting to influence a decision to be covered by this law. This obviously is very broad. A good rule of thumb is to ask yourself whether you are exercising discretion or judgment when you're confronted with a decision. Step 3, what economic interests do you have that may be impacted by decisions you make at your agency? The Act lists 5 categories of financial holdings or relationships that may trigger disqualification. I'm going to list them quickly and then we'll explain them in some detail. First, for-profit business entities. This includes 2 separate categories. One is outside employment and the second is investments. The second type of economic interest is real property. The third is sources of income. The fourth is sources of gifts. And finally, we cover financial effects on you and your immediate family from a decision. This is known as the personal financial effects rule. Now let's talk about the first economic interest, business entities. As I mentioned, this category is divided into 2 different aspects. The first is business positions. And this is just a term that means that the public official is an employee, a director, an officer, a partner, a trustee, or a manager of a business. The second aspect to business entities are investments. And this means that a public official has a direct or indirect investment of $1,000 or more in a business. The most typical example we see, I think, would be common stock in a corporation. Now, indirect investments are investments owned by the official's spouse, a dependent child, or anyone acting in the official's behalf, such as an agent. A dependent child is defined as one that's under the age of 18, and an agent is we use the common law definition. There is a very important rule that applies to business entities, and this is known as the pass-through rule. If a public official owns 10% or more of a business, the law pierces through it and considers all of its investments, real estate holdings, and income to be those of the public official. These are passed through in proportion to the public official's ownership stake. For example, if you own 1/3 of a software company you own 1/3 of the software company's income. Now let's turn to Kathy for our first review question.
Rosa is a member of a state board. In her personal capacity, she is employed at Madison's Hardware. Her husband owns 100 shares of Microsoft. In which of the following business entities does Rosa have an economic interest? A, Madison's Hardware, B, Microsoft, C, both Madison's Hardware and Microsoft, D, none of the above.
The answer to this question is C. And this question illustrates two different types of interest in a business entity. First, Rosa is employed by Madison Hardware. And you'll recall that we talked about one way to have an interest in a business entity is if you have an employment position with that business entity. So by virtue of working for Madison Hardware, she has an interest in that business entity. Now, she also has an indirect interest in the Microsoft stock by virtue of her husband's ownership of that stock. She owns it indirectly through him. And it doesn't matter whether that stock is held as community property or separate property. In the case of investments, in either case, they are indirectly held by the official. Steve?
The second type of economic interest is one in real property. A public official has a potentially disqualifying economic interest in real property if he or she has an equity or leasehold interest valued at $1,000 or more. Now, this does not include month-to-month tenancies. This, as above, also includes direct and indirect interests.
Locke is a member of a state commission and an attorney. He and his wife own a single-family home. He leases office space for his law practice. He also owns 2 of the 10 limited partnership shares in a limited partnership which owns a downtown office building. Which of the following, if any, are economic interests to Locke? A, his home, B, the office space he leases for his law practice, C, the downtown office building.
The answer to this question is A, B, and C. Let's go through each of those. With respect to the home, Locke owns the home with his wife. It wouldn't matter, though, if the home were owned solely by his wife. In either case, he either owns it directly or he owns it indirectly through his spouse. The office space that he leases for his law practice is also going to be covered. Remember that you don't have to own something in order for it to be an interest in real property, but many leases are covered as well. And thirdly, there's the downtown office building. In this one, he has a 20% share in the general partnership that owns the downtown office building. Because his interest is 20%, the pass-through rule is in effect, and we pass through the general partnership and to the holdings of the partnership. In this particular case, the downtown office building. So he would be deemed to have a 20% interest in that office building, and it passes through to him. And it doesn't matter whether or not the ownership of the downtown office building is listed in the general partnership or someone else. Because he has the 20% interest, it passes through to him. Steve?
The third type of economic interest is in sources of income to the public official. A public official has a potentially disqualifying economic interest in an individual or entity that has provided or promised income of $250 or more to the official in the 12 months immediately preceding the decision. The interest here is in the person who paid you or promised you the income, not the income itself. With income, you must remember to count your community property interest in the income of your spouse. Generally, 50% of any income to the spouse of a public official is attributed to the public official. Thus, let's say your spouse teaches piano lessons and receives income from a student of $500. The public official has an economic interest in that student that source of income of $250. Now, don't forget that income to a business entity, such as from a client or customer, may be passed through to you.
Hobbs is a state board member. Her husband, Calvin, is employed at Chimerical Industries. She owns 5% of a family corporation which runs a local heating oil business. Her share of the profits for the family corporation was over $5,000 last year. This business supplies fuel to many local businesses and residences. Which of the following, if any, describe sources of income to Hobbs? A, Chimerical Industries. B, the heating oil company. C, the customers of the heating oil company who have purchased more than $5,000 worth of heating oil in the past 12 months, since Hobbs' pro rata share of the business income from each such customer meets the $250 threshold.
The answer to this question is A and B. And if you get this one right, give yourself a hand, because this was a bit of a trick question. Chimerical is a source of income to Hobbs because of the fact that her husband works for it and receives income from it, and assuming that it is community property, it would count as a source of income to Hobbs. The heating oil company is also a source of income because she receives a share of the profits and income from it. However, the customers in this particular case do not constitute a source of income to Hobbs. And even though her pro rata share from each of the customers that pay $5,000 or more is the requisite $250, we didn't meet the 10% threshold in this case. The question indicated that she only had a 5% interest in the heating oil company, and therefore the pass-through test is not in effect.
The fourth type of economic interest is in sources of gifts to the public official. A public official has a potentially disqualifying economic interest in an individual or entity that has given the official a gift or gifts totaling $300 or more in value in the 12 months immediately preceding the governmental decision in question. So it's very much like the income rule. The amount is different, $300 instead of $250.
Holmes is the director of the State Department. He receives 2 gifts from a friend's business which is interested in the department's activities. In October, he receives 2 tickets to a San Francisco 49ers game, valued at $100. In February of the next calendar year, he receives a framed photograph of Yosemite, valued at $220. In June, he is considering a decision which would affect his friend's business. Does Holmes have an economic interest in his friend's business? A, Holmes has an economic interest in his friend's business because he received $320 worth of gifts within 12 months prior to the decision. B, Holmes does not have an economic interest because the gifts were received in separate calendar years.
The answer to this question is A, that you compute, in the case of disqualification, the incomes, whether or not they received a total of $300 or more, over a 12-month period as opposed to the calendar year. So it doesn't matter that the gifts were received over different calendar years because they both fell within the 12-month period. Now, there are other places, such as when we discuss the gift limit, where it's computed on a calendar year basis. But for disqualification, it's computed on a 12-month basis.
The fifth type of economic interest is known as the personal financial effect rule. I believe that this is the most intuitive of the economic interests. It provides that if a governmental decision will either increase or decrease the income, expenses, assets, or liabilities of a public official or the official's immediate family by $250 in any 12-month period, the official may not be involved in that decision. Now, let's say you're a pilot and you rent a hangar at the airport. You're also a member of the Airport Commission, and on the agenda this month, is a decision whether to increase the rents by $20 per month per hangar. You could vote on that decision because the most that your expenses would be increased in any 12-month period from that decision would be $240. Due to an exception in the definition of income for governmental salary, the personal financial effects rule normally will not prevent an official from being involved in decisions affecting the official's salary, per diem or expense reimbursements, or those of the official's spouse. However, this exception does not apply if the decision would single out the salary or per diem or expense reimbursements of the official or the official spouse.
Maria is the Deputy Director of the Department of Finance. Her husband works at another state agency as a civil servant. Maria is working on a pay raise for state civil service employees, including her husband. Does Maria have an economic interest under the personal financial rule?
The answer to this question is no. Although the personal effects rule would normally apply to this situation because of the fact that Maria's spouse is going to be directly affected by the decision, in this particular case, because it is government salary and because the spouse is not being singled out, the personal financial effects rule does not apply. In this case, Maria's spouse is going to be affected in the same way as all other civil service employees.
All right, so far we've covered steps 1 through 3. We have a public official making a governmental decision, and the decision implicates at least one of the 5 economic interests that we described. Now, in steps 4 through 6, we ask, is it reasonably foreseeable that the effect of the governmental decision on one of those 5 economic interests will be material? Step 4 asks, to what degree is the official's interest involved in the decision, directly or indirectly? Let's say you need a permit from the Planning Commission to build an addition onto your house. Your real property interest is directly involved in that decision. But consider a different situation. 5 houses down on your street, a neighbor is applying for a permit to build an addition to his house. Your real property interest in your house is indirectly involved in the Planning Commission's decision because your property's value may be affected. In step 5, you must look at the FPPC's regulations and find the materiality standard that applies to your facts. These standards are fairly simple if your economic interest is directly involved in the decision. If you have an economic interest, however, that is indirectly involved, the materiality standards are far more complicated. Most of the time, the standards measure the monetary impact of a decision on each economic interest that is involved in the decision. For real property interests, the materiality standards may also look at the distance from the official's property to the property that is the subject of the decision. Now, step 6 is the foreseeability test. You must make a prediction. Is it reasonably foreseeable that the material impact in the regulation, this monetary value, will occur from the governmental decision? If your neighbor wants to build a replica of an Egyptian pyramid in his yard, there is going to be a fairly substantial effect on your property's value. Will that effect equal or exceed the applicable materiality standard? You must look at all the facts and make the call. In close calls and where the decision is very important and you wish to participate, you may even wish to employ the services of an appraiser. Now, steps 7 and 8 are exceptions that allow a public official with a financial conflict to make or participate in a decision anyway. Step 7 allows an official to vote if the decision will impact a significant segment of the general public in a way that is substantially similar to the impact on the official. This public generally exception rarely applies. Now, let's take an example. Suppose a public official is a member of the Bay Area Rapid Transit Authority, the BART board. And let's say that this public official is a true believer in public transportation. He or she doesn't even own a car. And the decision facing the BART board at its meeting is whether to raise the fares for riding BART by 50 cents per ride. Now, also assume that this fare increase would affect this official's personal expenses by $250 in a 12-month period. The personal financial effects rule would be impacted. The public generally exception would probably apply under these facts because a significant segment of the general public, here the people who ride BART, would be impacted in a way that is substantially similar to the impact on the public official. Step 8 addresses situations in which the governmental agency must act, and the only way to act is to allow someone with a conflict of interest to participate in a decision. This is known as the rule of necessity or legally required participation. This is very rare, and it may not be invoked to break a tie on a board or commission. Well, we've talked about in these steps how you determine if you have a financial conflict. Let's say you do. Well, how do you disqualify? If you determine that you may not take part in a governmental decision due to a financial conflict of interest, you must disclose that fact. If you're the member of a voting body, you can state it on the record at a public meeting. If you're the head of an agency, you must disclose the conflict in writing to your appointing authority. For most of us, we can just give a memo to our supervisor. The disclosure should include a description of the economic interest that is impacted by the decision. Well, that concludes our discussion of the 8-step process.
Congratulations. You've made it through what is clearly the most difficult portion of the course that we're teaching to you today. We wanted to start there, though, because the first place to turn in any conflict of interest situation is the Political Reform Act. And it is a very well-defined area of law. The Commission has promulgated a number of regulations. There are formal opinions. And, of course, there is informal advice that you can get on a regular basis. So we want to tell you about a couple of other places where you can also get information about the Political Reform Act and the other conflict of interest laws we're discussing today. One place is from this pamphlet, which is produced by the Attorney General's office, and it covers pretty much all of the laws that we're discussing today. And we'll tell you where you can now acquire this pamphlet. You can acquire the pamphlet by mail by sending a request to the Public Inquiry Unit, Office of the Attorney General, which is at P.O. Box 944-255, Sacramento, 94244-2550. Now, the pamphlet is also available at the Attorney General's website. The pamphlet is online there, and you can acquire it there. In addition, the interactive internet version of this course is also accessible at that website. Steve, I believe you can also be reached by mail and by webpage.
The number for requesting advice from the Fair Political Practices Commission is 916-322-5660. We also have an excellent website, which is on the World Wide Web at fppc.ca.gov. And our fax on demand service has been extremely popular. The number for that is 888-622-1151, and that number is toll free. The next topic is gift limits and gift disclosure. The Political Reform Act places a limit on the dollar value of gifts you can receive. Currently, that amount is $300 per source per calendar year. The limit is adjusted at the beginning of every odd-numbered year to reflect changes in the Consumer Price Index. Now, there is a separate limit for lobbyists of $10 per month. This limit applies only if the firm or employer for whom the lobbyist works is registered to lobby your agency. For example, if you work for the Air Resources Board and a lobbyist from an oil company asks you to go to lunch, the odds are that you're going to McDonald's, and I would recommend that you do not go big on the fries and drink. In addition to the gift limit, a gift or gifts from one source aggregating $50 or more in a calendar year must be disclosed on your statement of economic interest. Now, by way of review, remember from the first part of the course that gifts can trigger disqualification. If a corporation buys you a round of golf at Pebble Beach for the next, and let's say it costs $300, for the next 12 months, you cannot be involved in decisions affecting that corporation. The application of the $300 gift limit, however, is not universal. Many of you must report gifts from any source. However, your conflict of interest code could say that you don't have to report any gifts. Or it could say that you just have to report gifts from particular sources, let's say people who are contractors of your agency, such as vendors. Just remember, the limit tracks disclosure. If you don't have to disclose a gift, there is no limit.
Leslie is the chair of a regulatory board. A friend of hers who is registered to lobby the board offers to buy her a $15 lunch. Can Leslie accept the lunch without violating the law?
The answer to this question is yes, because the lunch that was offered Leslie was $15 and the lobbyist gift limit is $10 per month. So obviously the lunch would exceed the lobbyist gift limit for that month.
For an official who is a designated employee in the Conflict of Interest Code, the gift limit applies only to sources of gifts covered by the official's disclosure category. True or false?
The answer to this question is true. The gift limit for designated employees tracks the disclosure category in their Conflict of Interest Code. So if you have to disclose the source of a gift under the provisions of your Conflict of Interest Code, then the $300 gift limit also applies to those sources of gifts.
How is the term gift defined? A gift is any payment that confers a personal benefit on the public official. The definition is very broad. If you provide goods or services in return of at least equal value, there is no gift. A gift includes a discount unless the discount is available to members of the public. When is a gift received? A gift is received when an official has actual possession of the gift or exercises any degree of control over it. And this would even include giving it away or throwing it away. So you have to be very careful. If a gift comes into your office and you don't want to accept it for whatever reason, especially if it's over the limit, do not give it to your secretary, because this is going to be considered a gift to you. If you don't remember anything else that I say about gifts, please remember that you may return or reimburse the donor within 30 days. So there's no need to panic. Now, how are gifts valued? Fair market value is the guidepost. If you can't figure out fair market value, and this should be extremely rare, ask the donor how much he or she paid for it. But be careful, because fair market value could, in some cases, be much more than the amount paid by the donor. Are there exceptions to the gift rules? Yes, there are numerous exceptions to the gift rules, and this is what adds complexity, I think, to this area. But we're going to cover some of those now. Some exceptions allow you to accept a payment and not report it at all. Others require you to report the gift, but they waive the $300 gift limit. Now, let me give you examples of both of these. In the category of no disclosure, and of course, as we said, if there's no disclosure, there's no limit, include gifts returned or reimbursed within 30 days, gifts from relatives, unused tickets, some travel inside California, informational materials, plaques, hospitality in a friend's home, and tickets to campaign fundraisers and charitable events. Now, in the second category, which are gifts that are reportable on your statement of economic interests, but not limited, are wedding gifts and prizes from a bona fide competition. In this category are also some types of travel expenses, which we'll talk about right now. We have an excellent brochure on these travel rules. There are separate rules for travel inside California, inside the United States, and foreign travel. I'm not going to cover foreign travel. Please contact the FPPC if you have any questions in this regard. If you are making a speech or appearing on a panel somewhere in California, payments by a third party for your transportation, meals at the event, and necessary accommodations are exempt from disclosure and are not limited. If you're traveling outside of California to make a speech in one of the other 49 states or the District of Columbia, and if the travel is related to a legislative or governmental purpose or to an issue of public policy, you may accept your transportation costs and 3 days worth of lodging and meals, the day before, the day of, and the day after the speech. However, as I mentioned before, you must report all of these expenses on your statement of economic interest. The $300 limit does not apply, however. If you are not making a speech and the travel is within the United States, including California, you may accept the payments if the travel is provided by a government or governmental agency, certain colleges and universities, and nonprofits that are exempt under Section 501c3 of the Internal Revenue Code. Again, the payments are reportable but not limited.
Eileen is the Deputy Director of a State Department. Her disclosure category in the Conflict of Interest Code requires that she disclose all gifts from all sources. Eileen is presented with a case of premium wine by a Napa winery in appreciation for her efforts in improving marketing of Napa wines overseas. In order to establish the fair market value of the wine, Eileen should A. Call the winery and ask for the retail price. B. Call the winery and ask for the wholesale price. C. Taste the wine and determine its value accordingly. D. Look for the price on the open market.
The answer to this question is A and D. And didn't you really want to answer C? Give yourself the taste test? But unfortunately, that doesn't work here. The answer is the retail value of it, or to go out and find it on the open market and establish the value of the gift in that fashion. Wholesale value doesn't count, and your personal assessment of the value doesn't count.
Dan, a member of a state commission, receives 4 front row tickets to an NBA basketball game from a business in town. He and his daughter use 2 of them and give the other 2 to his friend Pete. The face value of each ticket is $75, and the accompanying parking pass is valued at $10. Does Dan avoid potential violation of the gift limit by giving 2 tickets to Pete?
The answer to this question is no. When an official either possesses a gift or exercises direction and control over a gift, then that gift has been received by the official. So in this case, where Dan received the tickets and then passed 2 of them along to his friend Pete, all of these gifts are attributable to Dan.
Paul is the director of a State Department. He is offered an opportunity to rent a condo in Hawaii from Good Times, Inc. at its cost rather than the standard rental fee. Is the difference between the standard rental fee and the cost paid by Paul a gift?
The answer to this question is yes. The difference between the cost that was offered to Paul and the standard fee would be a gift. And that's because this was not a discount that was offered to the public generally without regard to official status, but instead it was offered only to Paul.
Linda is the chair of a state board. She is asked to deliver a speech in San Diego. She flies from her home in Sacramento to San Diego on Tuesday. She spends the night at a hotel, has dinner and breakfast, and gives her speech at 9 a.m. on Wednesday morning. She has coffee and a Danish during the break following her speech. She then returns home. A professional association paid for her airline flight, food, and lodging. By receiving the airline flight, food, and lodging, has Linda violated the gift limit? A, since the value exceeds $300, Linda has violated the gift limit. B, violation depends on her disclosure obligations. C, She has not violated the gift limit because these items are exempt from the definition of a gift. D, because the hotel and meals are exempt and the airfare does not cost $300, she has not violated the gift limit.
The answer to this question is C. This is one of those exemptions where, because it's a speech or a appearance on a panel or the conduct of a seminar within California, that the air transportation or the transportation to and from the event, incidental food and other items received at the event, and necessary accommodations in connection with the event are all exempt from the category of a gift. Now, in many situations, the answer B, which said it depends on the disclosure category, would be the right place to look. But in this particular case, it doesn't matter what her disclosure category was, because this kind of travel is exempt from the definition of the term gift wherever it appears. And so it really doesn't matter what her disclosure category is. This particular type of gift is exempt. All right, that concludes the discussion of the gift limits. So here are the points we want you to remember. The gift limit covers gifts totaling $300 from a single source in a calendar year. That's the general gift limit. The lobbyist gift limit covers gifts of $10 from a lobbyist or a lobbying firm in a month.
The next topic under the Political Reform Act is a discussion of the ban on receiving honoraria. The definition of honorarium is relatively simple, but the exceptions add a great deal of complexity. Basically, a public official may not accept a payment, and that includes cash or in-kind payments, for making a speech, publishing an article, or attending a conference, meal, or social event. The ban is limited to payments from a source from which you would have to disclose income on your statement of economic interest. Again, check your conflict of interest code. Now, there are several exceptions to the definition of honorarium. The first we just talked about, and that is payments for lodging, meals, and transportation in connection with a speech. The second one is you may return an honorarium to the donor or deliver it to the state controller within 30 days of receipt. If you cannot return it, you may reimburse the donor for the value of the honorarium. This latter option, however, is not available for cash payments. You must return the check or the cash. The third exception is a situation where you could direct that the donor give the honorarium to a charitable nonprofit. In these instances, you may not take a tax deduction for the donation, and you may not even be identified in connection with the payment. The fourth exception is the earned income exception. If the payment for a book or teaching a college course, for example, is in connection with a bona fide business, trade, or profession, it is considered income and not an honorarium. However, you must meet certain criteria. It is very helpful to maintain and be prepared to produce business and tax records, licenses, and teaching credentials. You may not make a speech under any circumstances in your official capacity and be paid for it. I recommend that you get the FPPC brochure on gifts and honoraria and contact us or your attorney if you still have questions.
Remember these points. Accepting a payment for making a speech, writing an article, or serving on a panel is prohibited unless an exception applies. Some travel benefits are exempt, but the rules are very technical. Your public office may not be used to generate additional income from speaking or writing. Unless you teach, a business set up to make speeches will not fall under the earned income exception. The ban strictly limits the return, reimbursement, and donation of an honorarium. If you receive an honorarium in cash, you may not later reimburse the donor. Once an official receives an honorarium, the ban may not be avoided by donating the honorarium to a charity. We're going to turn now to a discussion of some specific laws dealing with contractual conflicts of interest. When we deal with conflicts of interest that arise out of contracts, not only does the Political Reform Act apply, but we have these specific statutes that apply as well. So as we pointed out earlier, you have to check each law independently in order to make sure that you're free of a conflict of interest situation. The one we're going to start out with first is Government Code Section 1090, and this applies to all contracts. And that section provides that officials may not make a contract in which they have a financial interest. An official that has a financial interest that participates in the development of a contract violates Section 1090. Now, if there's no contract involved, Section 1090 is not applicable. Or if the contract that is being discussed is ultimately not executed, then no violation of Section 1090 occurs. Let's now go through some of the elements of the Section 1090 requirement. First, as we said, a contract is required. So a conflict of interest that arises out of the adoption of regulations, or the issuance of a permit, or the conduct of an investigation, or the issuance of a report is not covered by Section 1090. When we say contract, we are talking pretty broadly here under 1090. So it obviously covers written contracts. But in addition, it covers oral contracts. And it covers informal purchases. Say you take petty cash and go out and buy something for your agency. That also would be a contract under Section 1090. And in the state system, most grants are also considered to be contracts under Section 1090.
The Department of Cyberspace is considering regulations which would regulate access to the Internet. This would have an adverse effect on stocks owned by the Director of the Department. Does Section 1090 apply?
No is the correct answer in this instance because Section 1090 does not cover the making of regulations.
Let's turn now to a discussion of who's covered by Section 1090. And the answer is most officials are covered by Section 1090. It covers state officers and employees, and it covers local officers and employees. It covers elected representatives. It covers appointed officials. And it covers members of multi-member bodies, such as boards and commissions. What does it mean to participate in the making of a contract or to make a contract under Section 1090? The general rule is that participation in the making of a contract covers all preparations of the contract at any stage in the contract-making process. The contract-making process begins at the time when the idea for the contract first arises, all the way through the execution of the contract. So that means that plans in connection with the contract, deciding on the terms of the contract, the specifications in the contract, evaluation of bidders under the contract, and negotiation of the contract. All of these things are things that Section 1090 considers to be making a contract or participating in the making of a contract. Now, if it turns out that you do have a financial interest in a contract under Section 1090, the general rule is that all you need to do is disqualify yourself. Disqualify yourself from any participation at any stage of the proceeding. There are some limited exceptions which are strictly interpreted that may permit a person to go ahead and participate in the making of the contract, notwithstanding the fact that they have a financial interest. But these are few and limited. Now let's turn and see how the general rule is applied in the case of multiple member bodies, because it's a little different than it is in the normal situation. If you have a body with contract-making powers, then the members of that body are conclusively presumed to be participating in the making of the contracts under that body's jurisdiction. So, if you have a member of a body with contract-making power, and that member has a financial interest in the contract, that contract cannot be made. And even if the member disqualifies himself or herself from any participation, that's not enough. So let me say that again. If you have a member of a contract, of a board with contract power, and that member has a financial interest in the contract, that contract cannot be made. And disqualification from participation in the contract will not solve the 1090 problem. This is very different than the Political Reform Act, as you will recall, where all you ever had to do was disqualify yourself. But in the case of 1090 and multi-member bodies, disqualification will not solve the problem. Now, having stated the general rule, there are limited exceptions that will allow a person to actually disqualify himself or herself if they have certain kinds of financial interests. And these are called by the statute remote interests. But the term remote interest is specifically defined in Section 1090. It is not a generic term. You can't say, well, that interest is fairly attenuated or remote, so it must not be a problem. You have to go and specifically look at the way the statute is written to determine whether your type of interest qualifies for a remote interest exception. And if it does, then you can disqualify yourself. But again, these are exceptions that are limited and strictly interpreted.
Tom is employed in the Statistic Division of the department. He has discussed with his supervisor the benefits of contracting with a private vendor for certain services. Subsequently, the department decided to solicit bids from vendors for the performance of such services. Did Tom's conversation with his supervisor constitute participating in the making of a contract according to Section 1090?
Yes is correct in this example because Tom participated in the early idea development and reasoning stages of the contract-making process.
We'll turn now to a discussion of what constitutes a financial interest for purposes of Section 1090. And oddly enough, it is not defined in the statute. But the courts have given an interpretation to Section 1090 and what constitutes a financial interest. And the courts have interpreted it very broadly, using language such as, no matter how twisted and winding the trail, if the connection between the decision and the financial interest can be made, the violation is present. And under Section 1090, a financial interest does not mean that you have to benefit specifically from the making of a contract. Rather, the idea of financial interests in a contract really focus on relationships between the official and the contracting party. Let me give you an example from the local government arena. Assume that we have a city. The city council member also works for ABC Company, and now ABC Company wishes to contract with the city. Even if this contract will have no effect on the official in his private employment, there is still a financial interest in the contract under Section 1090 by virtue of the fact that the council member is an employee of ABC Company. And the same thing works, for example, that the attorney of a contracting party is deemed to have a financial interest in the contract, the stockbroker of a contracting party, the landlord or tenant of a contracting party, the supplier of goods or services to a contracting party. All of these relationships constitute a financial interest under Section 1090. An official also has an interest in the interests of his or her spouse. So any income or property interests of the spouse are also deemed to be interests of the official. And that is the case whether it is community property interest or whether it is a separate property interest.
Under Section 1090, the term financial interest is specifically defined in statute and regulation. True or false?
False is correct because the term financial interest is not defined in Section 1090 or in any regulation, but rather has been given a broad construction by the courts.
The separate property of an official spouse is not a financial interest under Section 1090. True or false?
The correct answer is false. Even the separate property of an official spouse is considered a financial interest under Section 1090.
Timing is crucial under Section 1090. As you know, officials may not make contracts in which they have a financial interest under Section 1090. But let's assume that we have a situation where at the time one becomes an official, the official already has a financial interest in an existing contract. That's not prohibited by Section 1090 because that contract is already in effect and it's already been made. However, a modification of that contract would constitute a violation of Section 1090. You can't exercise an option under a contract if you have a financial interest in that contract, nor can you participate in the renewal of a contract or the extension of a contract. All of these things are considered to be making a contract. Under Section 1090, there are harsh penalties for a violation, and this is one of the reasons why 1090 tends to be conservatively interpreted by lawyers who are providing advice to officials, because if you make a mistake, the sanctions under Section 1090 are so severe. Let me give you some examples. First of all, the contract itself may be declared void. Secondly, there are civil and criminal penalties that are available under Section 1090. And in fact, there is a permanent ban from ever holding office again in California for violations of Section 1090. Let me give you examples of two cases that recently occurred in California that demonstrate the adverse consequences of a 1090 violation. First is the case of Thompson versus Call, which was a case that went to the California Supreme Court. That particular case involved a three-way transaction between a city council member, and a third person. The council member transferred property to the third person, who in turn transferred that property and others to the city. And even though the council member did not participate in any aspect of the decision to acquire the property, the court concluded that 1090 had been violated and therefore required the council member to forfeit the benefits of that contract. So the government got to retain the property, and the council member had to return the $258,000 that he had received for that property. And the court went out of its way to say it didn't matter whether the contract was fair, or even if it were advantageous to the public entity. Section 1090 would still be violated, and the fairness of the contract was irrelevant. In People versus Honig, the former superintendent of education for California was criminally convicted of making contracts in which he had a financial interest. And as a result of that, he was required to surrender his public office.
A violation of Section 1090 can lead to which of the following? A, a void contract. B, the state retaining benefit and the contractor having to return any payment received. C, a felony conviction. D, permanent loss of office in California.
The correct answer is all of the above. The contract is void, the state retains the benefit, and the contractor must return any payments. A violation of Section 1090 is a felony, and the violator can lose the right to hold office in California permanently. Now that concludes our discussion of Section 1090. So you should remember these points. Section 1090 applies to contracts. Participation by a public official at any stage of the process counts. The term financial interest is very broadly defined. A violation of Section 1090 voids the contract, but the government keeps the benefits. Penalties are a felony and a permanent ban from holding office.
Next, we're going to turn to a discussion of Public Contract Code Section 10410. And this section pertains only to state contracts as opposed to Section 1090, which applies to all contracts. It imposes some additional restrictions, and these restrictions come in two parts. First, there's a general ban on having financial interests in contracts, and it is very, very broad. The elements of the ban are that no officer or employee shall engage in any activity, enterprise, or employment in which the official has a financial interest or from which the official receives compensation if the activity, enterprise, or employment is sponsored in whole or in part by a state contract. There are some limited exceptions to this ban, especially for part-time board members and for certain computer contracts. The real point is that if you are involved in the making of state contracts, you need to consult with your counsel about the application of Section 10410 of the Public Contract Code. The second part of the ban relates to independent contracting. It provides that no officer or employee shall, as an independent contractor, engage in a contract with the state for the supply of goods or services. Like Section 1090, violation of this provision has some harsh penalties. The contract can be voided, and there are criminal and civil sanctions that can apply. Next subject is called the Code of Ethics, and it's in Section 8920 of the Government Code. We'll have just a brief discussion of this section. It provides that officers may not participate in decisions which will have a direct monetary effect on them. This particular provision does not apply to civil services employees, but only applies to officers. Specifically, it provides that no officer shall have a direct or indirect financial interest or engage in any business transaction or professional activity or incur any financial obligation which is in substantial conflict with the discharge of the official's duties. Substantial conflict with the discharge of an official's duties is defined in the statute as meaning that the decision will have a direct monetary effect on the official, either a gain or a loss. So the statute starts out by saying that an official shall not have a direct or indirect financial interest, but it ends up by defining a substantial conflict as meaning a direct monetary effect on the official. So even though the language appears to be broad in the beginning, it's ultimately very narrow in terms of how it's defined. Now, if there is going to be a direct monetary effect on the official need only disqualify himself or herself in order to avoid the problem. And there is a major exception to this provision. That is, if the officer is going to be affected in the same way as members of a business or an occupation or a profession or some other large group of that type, then the provision does not apply in that case. The violation of Section 8920 is punishable as a misdemeanor. Steve, you want to remind them of the major points?
The Code of Ethics applies to state elected and appointed officers, but not to civil service employees. In addition, officers are prohibited from participating in decisions that will have a direct monetary effect on them.
Next subject we're going to turn to is called the ban on free transportation. What this section, which is contained in the Constitution, provides is that officers may not accept passes or discounts from transportation companies. It's contained in Article 12, Section 7 of the Constitution. And the origins of this provision lie with the early days of California and the historical relationship between the railroads and the legislature. This ban is focused on the perceived corruptive influences of gifts of free transportation to members of the legislature and other public officials. Now, interestingly enough, this section was proposed for repeal in 1970 and placed on the ballot. But the voters defeated that repeal, and so it's still in effect. The elements of the ban are as follows. Transportation companies may not make gifts or discounts in transportation to public officers. The ban applies to officers and not employees. It applies to both appointed and elected officers. The ban applies to foreign and domestic travel. The ban applies to transportation received either in the official's personal capacity or in connection with the performance of his or her public duties. And the penalty for violating the ban is forfeiture from office. Let's go through the individual elements now. The first one is that it applies to gifts of transportation from a transportation company. That means that it does not apply to gifts of transportation from other kinds of companies. So, for example, a gift of air travel from an airline would violate the ban, but a gift of air travel from, for example, General Motors would not violate the ban. Also, if a gift of transportation is made, for example, to a bona fide charity, and then the charity ultimately gives it away, that would not be a gift of travel from the transportation company, but rather from the charity. Now, one way to avoid problems with the ban is to pay for the transportation. But if you go to pay for the transportation, you need to make sure that you pay full value. And that includes all the benefits that are received in connection with the transportation. An example is that a few years ago, a railroad sought to bring a number of public officials from San Francisco to Sacramento to the Dixieland Jazz Jubilee. But they didn't just give them a train ticket. Instead, they had a special antique car that they were to travel on. There were food and beverages and entertainment. So the advice was that in making full payment for this transportation, all of those benefits had to be taken into account and paid for. Now, the ban does not apply when the official receives the gift of transportation as part of a group that is unrelated to the officer's official status. An example was that a state officer was married to a flight attendant, and the flight attendant, as part of her employment package with the airline, received discounts in travel, which she was allowed to pass on to her husband. In this particular situation, this did not violate the free transportation ban because the official received it as part of his wife's employment package and did not receive it in connection with his being an officer with the state. Similarly, where an airline offered a free first-class upgrade to all honeymooning couples, and a state officer was on his honeymoon and received the gift of free transportation in that context, it did not constitute a ban of the free transportation. However, where a gift was made to a mayor as part of a program to recognize prominent members of the community, that was a violation of the ban because it was directly related to the mayor's official status as a reason for why he received the gift of transportation.
Cy is a deputy director. He has accumulated 20,000 miles on his personal frequent flyer plan. He is entitled to a round-trip ticket to any location in the country where his airline flies. A. Cy may accept the free ticket because it was earned as part of a program designed to promote that airline, and the program was offered to the general public without regard to official status. B. Cy should not accept the ticket because he did not pay full value for it.
The correct answer is A. It was the official's personal frequent flyer program, and it was offered by the airline to the general public without regard to official status.
Okay, let's turn now to a discussion of who's covered by the free transportation ban. And the answer is that it's officers and not employees, although it's not always easy to tell exactly who is an officer and who is an employee. An officer generally exercises some portion of the sovereign power, which, let's face it, is a bit of an obscure phrase. So what it really means in most cases is a person who participates in setting policy as opposed to someone who merely advises probably is an officer. The ban also applies to intrastate and interstate transportation. Over the years, advice that has been given and interpretations that have been made of the section have extended it so that it applies to carriers and transportation received both inside and outside of California. And it doesn't matter whether or not the particular carrier does business in California. So a California official who's traveling in the Midwest and receives a gift of free transportation from a carrier in that other state which does not do business in California, there's still a violation of the ban under those circumstances. The ban also applies whether or not the officer receives the transportation in his or her personal context, or whether or not they receive it in connection with the performance of their public duties. There is a specific exception for the Public Utilities Commission, but not for any other officers. Finally, the remedy that the ban provides for violation is forfeiture of office. So, if transportation is accepted by an officer in violation of the ban, then the provision provides that that person shall lose their office in California.
Janet is a deputy director of a state agency. An airline wishes to persuade California to embrace a new technology in public transportation. The airline wishes to give Janet a pass on its airline to fly her to Germany to witness the technology and receive briefings on its future development. Receipt of the transportation is not a violation of the ban because there is no intent to benefit Janet personally. True or false?
The answer to this question is false. The ban applies whether or not Janet personally benefits.
Susan is a civil servant computer programmer who works for Janet. She has been offered a free ticket to Hawaii by an airline. Would she be in violation of the ban if she accepted the ticket?
The answer in this case is no, because the ban applies to officers but not to employees.
Now assume that Susan is promoted to officer status. The airline that gave her the trip does not do business in California. Acceptance is A, a violation of the ban. B, a violation if the airline is contemplating doing business in California because the gift may be an attempt to influence the government. C, not a violation of the ban.
The correct answer is A. The ban applies whether or not the company does business in California.
James works for an airline and convinces his employer to donate 2 round-trip tickets to his favorite charity. The tickets are used as a door prize at a fundraising event. Keith, the director of a department, attends the fundraiser and wins the tickets. A, Keith's acceptance of the gift would not violate the prohibition so long as it is intended for his personal use and not for business purposes. B, Keith's acceptance of the tickets would not violate the prohibition unless they are for an out-of-state destination. C, Keith's acceptance of the tickets would violate the ban. D, Keith's acceptance of the tickets would not violate the ban since they were provided to Keith by the charity and not the airline.
The correct answer is D, because the tickets were a bona fide gift from a charity rather than from the transportation company.
Jeff accepted transportation in violation of the ban. Based solely on the ban, A, Jeff must reimburse the transportation company for the full value of the gift or discount. B, Jeff may be subject to criminal prosecution. C, Jeff may be removed from office. D, Jeff may be subject to a civil lawsuit for money damages.
The correct answer to this question is C. Under the ban, the only sanction is removal from office. Now that concludes our discussion of this topic, so you should remember these points. The ban on free transportation applies to passes or discounts from transportation companies. It applies only to officers, not to employees. It covers both personal and business use. It covers inter as well as intrastate transportation companies. And finally, violation means forfeiture of office.
We're going to discuss incompatible activities for state officers and employees. Government Code Section 19990 prohibits officers and employees from engaging in activities which are inconsistent or incompatible with their positions as state officers and employees. Agencies are required to adopt incompatible activities statements which outline the particular activities that are prohibited. Because you are probably covered by an incompatible activity statement, you need to get a copy of your agency statement and examine it so you will know what activities are prohibited for you. Now, what kinds of things are included for coverage under Section 19990? There are some activities which are outlined in the statute and must be included in all incompatible activity statements. However, there are others that agencies may include at their own option, and these can vary widely. Some of them relate to the way in which people perform their official duties, but others of them relate to activities that a person may be involved in their private life after hours. The purpose of the incompatible activity statement is to identify these activities and to provide clear notice to the people who work in a department as to exactly what is permitted and what is prohibited. For civil service employees who violate an incompatible activity statement, they are entitled to the same notice and appeal rights as they would have for any other kind of personnel action. Now let's go through some of the things that are specifically prohibited by Section 19990. First is that an officer or employee may not use his or her prestige or influence in order to achieve some kind of personal gain. So, for example, you can't use your official title or your letterhead in order to acquire some personal gain for either yourself or others. Second, you can't use state facilities or resources for personal gain. That would include equipment, the compensated time of an employee, computers, telephones, faxes, cars, mail, office space. Any of these kind of things cannot be used for one's personal purposes. Confidential information may not be used for personal purposes. Information that might be contained in a personnel file or information in an investigation file. These things cannot be used for personal purposes. It also provides that the compensation which the state provides to its employees represents the full amount of compensation that an employee is allowed to receive for the performance of official duties. Your salary has been established as the appropriate payment for your services, and you're not allowed to receive any other services for the performance of your official duties. You cannot review or regulate your own activities. You also cannot accept gifts from contractors or would-be contractors with your agency where it would reasonably appear that the gifts were made to either influence you or to reward you for your official duties. Now, all of these things are in addition to things contained under the Political Reform Act related to gifts. There is no specific penalty outlined in Section 19990 for its violation, but civil service laws do provide that the violation of an incompatible activity statement is the basis for discipline for civil service employees. Also, as you can probably tell from just listening to this discussion, the violation of the incompatible activity statement may subject one to violation for other laws as well. For example, if you misuse public property under the incompatible activity statement, you may also be subject to criminal penalties under the penal code for misuse of public resources. Steve, can you remind us of the high points?
I'd be glad to. These are the points that you should remember. Obtain a copy and examine your agency's incompatible activity statement. Use of state time, resources, and prestige for private gain is prohibited. Acceptance of a gift is prohibited if 1, it is intended to influence or reward the official, and 2, if it is from a person doing business with the agency or is regulated by the agency. Finally, violations may result in personnel, civil, and/or criminal sanctions.
We just finished discussing incompatible activities for state officers and employees. We're now turning to the doctrine of incompatible offices, which sounds a little bit the same, but in fact is quite different. What this doctrine concerns is the clash between two public offices held by a single individual. In other words, what the doctrine is concerned about is a conflict in the performance of one's public duties, where the two offices involved are overlapping or conflicting in some respect. This is distinguishable from the other types of conflicts of interest that we've been discussing today, which generally involve a private financial interest on the one hand and a public office or public duty on the other. This particular doctrine deals with a situation where we're talking about both public offices, but they're held by a single individual. Now, this is important to you because during your tenure in state service, you may be asked to assume some other kind of office. And if that comes up, then you'll need to know about this doctrine in order to make sure that you don't have a problem. There are two elements that are required in order to come within this particular doctrine. First is that you must be holding two offices simultaneously. Second is that there must be some potential for a conflict or overlap in the two offices. Now, this particular doctrine is a court-made law, so the legislature can enact legislation which supersedes this common law doctrine. And that means that notwithstanding the common law doctrine which may say that it's a violation to hold two offices where there's overlapping jurisdiction, the legislature can come along and say in particular cases it's okay. There are public policy reasons why it's all right to have this kind of conflict. And let me give you one example. Say you have a state agency, and that state agency then it becomes a party to a joint powers agreement. Now, the state agency in its individual capacity and the joint powers agency may not always have the same goals, and they may conflict in their policies. But under the statute, it's okay for a person to both be an officer with the state agency and also an officer with that joint powers agency, which has as one of its members the state agency in question.
The doctrine of incompatible offices is concerned with a potential clash between A, a public office and a private office, B, a public office and a private financial interest, C, two public offices held by different people, D, two public offices held by a single person.
D is the correct answer. A is incorrect because the doctrine of incompatible offices does not apply to a private office. B is incorrect because the doctrine of incompatible offices concerns only public offices, not private financial interests. And finally, C is also incorrect. The potential clash is between two offices held by a single official.
The doctrine can be superseded by legislative enactment. True or false?
In this case, true is the correct answer. the doctrine can be superseded by legislative enactment.
Next, we'll turn to a brief discussion of who's covered by the doctrine of incompatible offices. As it indicates, this is a doctrine dealing with public offices, and therefore officers are covered and employees are not covered by this particular doctrine. Once again, we have the problem of identifying what is an office versus an employee, and it has to do with the exercise of sovereign power and the participation in policy-making functions. If the person is a policymaker, then they're probably an officer. The issue of whether or not a deputy holds an office under the doctrine, again, depends on the policy-making power of that deputy. Deputies who do not exercise policy functions are not covered under the incompatible offices doctrine. Examples of offices that are covered include elected officials, agency secretaries, department directors, deputy agency secretaries and deputy directors, and also members of boards and commissions. Examples of persons that are not covered are clerical personnel, mid and low-level civil servants, or other persons who do not exercise discretion in the performance of their official duties.
If a position is important, it need not be an office to be covered by the doctrine. True or false?
False is correct. Only offices are covered by the doctrine.
Office includes A, a principal and all of his or her deputies, B, only persons appointed by the governor, C, only elected officers, D, positions which are established by state law and exercise a portion of the sovereign power, E, high-level employees.
The correct answer to this question is D. A is incorrect because the doctrine of incompatible offices concerns the deputy only where the deputy stands in the principal's shoes with respect to policy-making decisions. B and C are also incorrect because the doctrine of incompatible offices covers all public offices. E is incorrect because the doctrine of incompatible offices covers offices, not employees.
Under the doctrine of incompatible offices, the conflict need not be actualized. By that, I mean that you don't have to have a particular conflict in order to activate the doctrine. The potential for a conflict to arise is sufficient to activate the doctrine. The Supreme Court indicated that the purpose of the doctrine is to make sure that public officials have undivided loyalty to the exercise of their office. And the problem is that if there is a potential for two offices to overlap and conflict, then we don't have that assurance. Now, one way to determine whether or not there is an incompatibility is whether or not one office has some power over another office. A local government example to make this point is where you have a water district and a school district. You have one person who sits on the board of both of those agencies, and they exercise jurisdiction over some of the same geographical area. In that situation, should the school wish to change its water connections or expand, it would be subject to the jurisdiction of the water district. And in that situation, we could be in a situation where the interests of the school district and the interests of the water district are not the same. Similarly, where we have a city council member who also sits on the State Highway Commission, there can be a conflict between the city's interests and the interests of the state highway program with respect to the placement of highways. Penalties under the doctrine are the automatic vacation of the first office. So if we have incompatible offices, what the doctrine says is that the one that was most recently assumed is retained and the prior office is automatically vacated. Obviously, this can be of tremendous significance to people when they're being paid for one office and not for the other.
Offices are generally incompatible if A, one exercises regulatory or budgetary authority over the other, B, the offices are of the same type but in different jurisdictions, C, the offices exercise authority over the same geographical area.
The correct answers are A and C. The doctrine of incompatible offices applies if the offices have overlapping budgetary or regulatory power. It also applies where the offices exercise authority over the same geographical area.
When an officer holds incompatible offices, A, the office holder may be asked to resign one of the offices. B, the office holder is deemed to have vacated the first office. C, the office holder must disqualify himself or herself from the decision in question. D, the office holder will receive administrative fines.
The correct answer to this question is B. If the doctrine applies, the office holder is deemed to have vacated the first office. Now that concludes our discussion of the doctrine of incompatible offices. Here are 4 points you should remember. The doctrine applies only to offices, not to employment positions. Potential conflict is sufficient. An actual conflict between the offices is not required. If the offices are incompatible, the first office is deemed to be vacated. And finally, disqualification will not cure the incompatibility.
Okay, we're now kind of starting down the home stretch. We're nearing the end of the course. We're turning now to a discussion of misuse of public funds. Public funds may not be used for personal purposes. The starting point for any discussion of the misuse of public funds is with the principle that public funds must be expended for an authorized public purpose. Expenditures are made for a public purpose when the primary purpose for the expenditure is to benefit the public. However, once a public purpose is established, the expenditure still must be authorized. Government officials possess only that authority which is conferred upon them, either expressly or implicitly. Under the Constitution and the laws of this state, public funds cannot be spent for a purpose which is primarily private. Such an expenditure is neither for a public purpose nor is it authorized. However, the fact that an expenditure will have a personal benefit does not mean that the expenditure is made for a personal purpose. An example would be that when an employee of the government is paid a salary, that confers a personal benefit. However, it's still an expenditure made for a public purpose, because the purpose of the expenditure is to secure the skill of that employee to be used on behalf of the public. A misuse of public funds occurs where the personal benefit is not merely incidental.